Good afternoon, friends. Today intend to talk about civil suit and what kind of preparation one has to do while preparing a civil suit. Although what I am trying to say is not new at all, nevertheless, I am trying to speak and state the facts in a more simple manner, which may be useful for law students and the advocates who have started their practice in right earnest and they are doing practice in the field of civil suits. There are different stages of civil suit. A first stage of the civil suit is the filing of the plaint. The first stage in the civil suit is the filing of the plaint, which outlines the facts, legal grounds, and reliefs sought by the plaintiff. And the relevant legal provision is Order 7 of the Civil Procedure Code, CPC 1908, which deals with the format and requirements of a plaint. Here, the advocates must ensure that the plaint contains all necessary facts, legal points, and correct cause of action. Any omission can lead to rejection or delay. So one has to be very meticulous about documentation, especially with respect to court fees and jurisdiction part. Apart that, the most important feature of the plaint is clause. So relief clause has to be drafted very carefully. Any ambiguity can restrict the court's power to grant full relief. The second stage is called service of summons. After the plaint is filed, the court issues a summons to the defendant to appear and answer the claims. The relevant legal provision, Order 5 of CPC, outlines how summons should be served. Here, the advocate must ensure that summons are served correctly and timely, and a delay in service can result in the suit being prolonged unnecessarily. Further, use electronic or registered post methods for faster and more reliable service, especially in complex cases involving multiple defendants. The third stage is what we call as filing of the written statement. Now here, the defendant is required to file a written statement responding to the plaint and raising any defenses. Relevant legal provision is Order 8 of CPC, which covers the filing of written statements. For advocates, at this stage, it is necessary that for plaintiffs be vigilant about ensuring that the defendant adheres to the 30-day time limit for filing the WS. Delay should be noted and objected to it if necessary. For defendant also, the one must draft the WS comprehensively, addressing every fact alleged in the plaint, and we have to be sure to include all defenses and counterclaims. Incomplete defenses can limit one's options at a later stage. The fourth stage is what we call as framing of issues. Now, once the pleadings, plaint and WS, are complete, the court frames the issues, which are the points of contention to be adjudicated. The relevant legal provision is Order 14 of CPC, which covers the framing of issues. Now, it is for the advocates to understand that at this stage they should request the court to frame issues clearly and concisely. Narrowly framed issues help focus the litigation and save time. And if by chance court misses any relevant issue, please highlight and state the same and pray for additional issues to be framed immediately as this will streamline the evidence stage. After the framing of issues, the stage comes, what we call it as evidence stage. At this stage, both parties present documentary and oral evidence to support their claims and defenses. The relevant legal provisions is in this context are Order 18 of CPC, which governs the presentation of evidence. The Indian Evidence Act 1872 also applies to the admissibility and relevance of evidence. So one has to be very, very careful in understanding under Indian Evidence Act 1872 what are the facts or issues which are admissible and relevant of evidence. And in this context, it is very important to state that the advocates must prepare witnesses well in advance, ensure that they are comfortable and are familiar with the facts of the case. A poorly prepared witness can damage a case. Apart that, the advocates are expected to organize documents systematically as a court will look for specific evidence supporting each issue. After the evidence stage, a very crucial stage comes of cross-examination. Both parties have the opportunity to cross-examine the opposing party's witnesses to test the veracity of their statements. Now, the relevant legal provision is the Indian Evidence Act 1872, particularly sections 137 and 138, that governs cross-examination. And one is expected who are doing these civil suits, civil side court cases, that they must understand the sections 137 and 138, which governs cross-examination in a very clear manner, so that they can do their work in a professional way. Advocates, one must ask targeted and clear questions during cross-examination, and one must avoid unnecessary questions that may allow the witness to reinforce their testimony. And more so, focus on contradictions in their testimony or omissions in their affidavits is a crucial exercise, as that will help at the argument stage. Now, after the cross-examination, we have got the final arguments. After the evidence is presented and witnesses are examined, both parties present their final arguments to summarize the case. And at this stage, the final arguments to weave all the evidence into a cohesive narrative. And one must re-emphasize the key facts, laws, and legal precedents that support the client's case. And very, very important at the final argument stage is this: one should and must avoid introducing new arguments or evidence. At this stage, stick to the issues framed and evidence already on record. The next stage after final arguments, we call it as a judgment by the court. The court delivers a judgment based on the pleadings, issues, framed evidence, and arguments. The judgment can either favor the plaintiff or the defendant, or the court may issue specific directions. The relevant legal provision under this context is Order 20 of CPC govern the delivery of judgments. Now, before the judgment, one must make sure that all relevant precedents, laws, and facts are highlighted and clarify any ambiguities in your client's favor during arguments. At this stage, the lot of research has to be done in support of your arguments in the context of case laws of different high courts and Supreme Court, the latest ones, that will reinforce your pleadings. And one should also be prepared for a possible appeal options in case of an adverse judgment. Now, after the judgment, we call it decree. Now, what is decree and what is judgment? A decree is a formal expression of the judgment. It outlining the rights and obligations of the parties. And the relevant legal provision, the most important one is Section 2.2 of CPC defines a decree, and Order 21 governs the execution of decrees. Here, one must ensure that the decree accurately reflects the court's judgment, reviewed thoroughly to avoid any discrepancies or ambiguities that could create issues in execution. This is a very important development at this stage. Now, after the decree, it comes to execution of decree. If the judgment is in favor of the plaintiff, the next step is to go for execution of the decree. Now, this may involve monetary compensation, property transfer, or other remedies. Other relevant legal provision is Order 21 of CPC that governs the execution proceedings. Now, the advocates at this stage must expedite the execution process. Now, delays can frustrate your client and lead to unnecessary expenses. File for execution without delay once the decree is final. And after that, monitor the other parties' compliances and file necessary enforcement petitions if they fail to comply with the court's directions. Now, these are the basic facts or stages in a civil suit. I hope that my this simple narration may help the students of law and the advocates, young advocates who have started their career in the legal profession. There are landmark judgments of Supreme Court regarding the decree and execution of decree, etc., etc. I have tried to avoid the case law relating to these different orders of the CPC, as in that case, my humble talk herewith would have become very comprehensive. I hope what all I have stated is nothing new, but the students of law and the young budding advocates may little be helped or enriched by this presentation of civil suit and the tips that have been given or suggestions that have been given in the course of my talk herewith. Thank you very, very much.